So today, welcome to Constitution Day, and in case you don't know about this, I've got to give you a little introduction before I introduce our speaker. Wikipedia, of course, has everything right. Constitution Day, or Citizenship Day, is an American federal observance that recognizes the adoption of the U.S. Constitution and those who have become U.S. citizens. It is normally observed on September 17th, the day in 1787, write that one down. The delegates to the Constitutional Convention signed the document in Philadelphia. Our illustrious UC president sent out a note to students that said, in 2005, the federal government enacted a law that requires all schools receiving federal funds to hold an educational program on the U.S. Constitution each year on September 17th, Constitution Day. As students of the University of California, you're privileged to have ready access to a range of historical, political, sociological, and legal perspectives on the study of the U.S. Constitution. And since we are being sponsored by the library here, I'm very happy she added, I urge you to explore UC's print and electronic library holdings on the Constitution. Take a Constitution-related course outside your major, history, political science, law, legal studies, or engage in a research-oriented enterprise such as independent study. I hope you enjoy broadening your knowledge of the Constitution during the coming academic year, which we are in. I was reading the Berkeley blog a few months back, and one article that drew my attention was from Stephanie Jones-Rogers. And the news center on the campus mentioned this about it. Recently, I was watching television and became captivated by the story of a fascinating woman, Stephanie Jones-Rogers writes this week in the Berkeley blog. She was born to parents who claimed one racial identity, which was affixed to her through infancy, childhood, and adolescence. When she grew to be a woman, she made a choice to become someone else. But Jones-Rogers, a UC Berkeley assistant professor of history and expert in 19th century African-American history, the history of American slavery, and women's and gender history in the United States, isn't talking about news headliner Rachel Dolezal. And she was the woman in Spokane, Washington, who was the head of the NAACP that was criticized for not being black. Rather, she's talking about Elvira Frederick, a woman born in 1921 to parents of African descent who at 18 decided to remake herself by moving north and becoming a white woman. Jones-Rogers says Dolezal's story gives Americans an opportunity to consider how we become so multiracial to begin with, a history bound to American slavery, and wonders how the conversation about race could change. Stephanie Jones-Rogers, an assistant professor of history at UC Berkeley, and is currently working to complete a regional study which draws upon formerly enslaved people's testimony, slave traders' papers, legal documents, financial records, travel writing, and other narrative sources to dramatically reshape our understanding of white women's economic relationships to slavery, how their investments in the institution shaped their gender identities, and how these women's economic choices impacted the lives of the enslaved people they owned. Professor Jones-Rogers earned her bachelor's, her master's, and her doctorate at Rutgers, the State University of New Jersey. She has taught at the University of Iowa and at Tulane, and she joined us here at UCB last year in the history department. She won the Lerner Scott Dissertation Prize from the Organization of American Historians for the best doctoral dissertation in women's history in 2013. I am very pleased to welcome Stephanie Jones-Rogers.
Okay. So first I'd like to thank the Free Speech Movement Cafe Programs Committee, especially Virginia Shee, David Dewar, and Crystal Miles for inviting me to talk with you today, and for all of their help in making sure that this event unfolded without a hitch. And thank you all for coming tonight. It's a wonderful thing about Berkeley. There's so many events that you can choose from, and I'm very happy and pleased to know that you chose to come to this one. So let me begin by telling you about a series of court cases involving a slave-owning woman named Mary Martin and a man named Jack. On February 27, 1830, Mary bought Jack, who was 30 years old at the time, from a New Orleans slave trader named John Woolfolk for $550. As the custom went in the New Orleans slave market, John Woolfolk guaranteed that Jack was free of all vices and maladies. Comforted by Woolfolk's assurances, Mary finalized the transaction with the slave trader and took Jack home. However, within a month's time, Mary discovered that John Woolfolk's guarantee was in fact an empty promise. Jack was afflicted with the vice of running away, and he was gone. Mary accused Woolfolk of knowing that Jack was an unsound purchase, and she even alleged that he bought Jack out of the Charleston, South Carolina jail or workhouse or house of correction, all of which were places where slave owners frequently sent recalcitrant slaves for punishment. Immediately after Jack fled, Mary searched for him for 2 months without any luck. Exasperated, she approached John Woolfolk and demanded a refund, and he refused. In the face of his refusals, Mary took her demands a step further and entered the New Orleans First Judicial District Court. After hearing the facts of the case, the court discontinued Mary's lawsuit, in part because the judge determined that her charges against John Woolfolk were groundless. His counsel called several witnesses to testify. Some of them even owned Jack before Mary did. And they all attested to Jack's excellent character and claimed that he had never been housed in any of the places that Mary alleged he'd been. While Mary may have lost her case against Woolfolk, she remained undaunted and refused to end her pursuit of justice there. Mary realized that the Constitution of the United States and other federal and state legislation which supported it gave her the power to find Jack wherever he might be and to take him to New Orleans. The text of Article 4, Section 2, Clause 3 of the Constitution states the following: "No person held to service or labor in one state under the laws thereof, escaping into another, shall in consequence of any law or regulation therein be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due." So according to this clause, enslaved people would not be emancipated by simply running away from their owners and entering another, presumably free state. Furthermore, anyone responsible for finding the fugitive was obligated to deliver them to the person who claimed them. In spite of appearances, however, legislators realized pretty early on that the Fugitive Slave Clause didn't really have teeth. So they passed the 1793 Act Respecting Fugitives from Justice, which equipped the constitutional clause with a set of very sharp teeth. The 1793 Act empowered slave owners, their agents or attorneys, to seize or arrest fugitives and to take them before a judge or magistrate in any state, including allegedly free ones, and prove ownership and entitlement to their labor. It also required that these officials to adjudicate these cases, and if they received satisfactory proof of ownership, the act obligated them to give a certificate to the slave owner or their representative, which permitted the enslaved person's removal to the state from which they fled. The 1793 Act also punished those who tried to hide enslaved people or otherwise prevent their removal. They could be fined $500, the equivalent of $12,300 today, or rather in 2014 money, and these funds would be handed over to the slave owner along with their slave. So, according to the Constitution and the 1793 Act Respecting Fugitives from Justice, Jack was a fugitive from his service and labor, and as his legal owner, Mary was entitled to both. Acting upon this premise, Mary turned her attention away from Woolfolk and relentlessly searched for Jack until she found him. 2 long years later, 2 long years after Jack escaped, Mary found him over 1,300 miles away in New York City. Now, let's think about that for a minute. Jack's journey was over 1,300 miles, and that 1,300 miles is charted by this red arrow on the map here. This means that he quite possibly moved through at least 10 states that were invested in or friendly to slavery. And yet he survived the journey and made it north, where he was living as a free man. But after all of this, Mary found him anyway. And in August of 1833, she presented an affidavit to authorities in New York, which by all measures would be considered a free state, and claimed that she was entitled to Jack's services because he was her slave for life. She also offered evidence of her legal ownership and asked the court's permission to take him out of the state and back to New Orleans. The recorder of New York, who was responsible for evaluating the credibility of Mary's affidavit, deemed the information she provided to be legitimate, and he granted her request. He then issued her a certificate of apprehension, which allowed her to remove Jack from New York without interference. But Jack had other ideas. He appealed the recorder's decision, denied that Mary owned him, and reasserted his claims that he was a free man. He claimed that Mary had actually moved to New York City permanently on March 1st, 1833, and argued that her decision to do so granted him freedom. Free state, free man, he figured. Of course, Mary denied all of this. But in any case, Mary and Jack were embroiled in 2 years' worth of litigation, and the case eventually made it to the New York Supreme Court. Mary entered not one, but 3 courtrooms. 2 of them were over 1,300 miles away from her home, just to get Jack back. This wasn't an act of benevolence. It was an act of economic self-interest. She paid $550 for Jack's body, an amount which would have the buying power of over $14,000 today. And when she lost him, she either wanted her slave back or her money back. She made demands upon powerful and wealthy men who she expected to aid her in this mission. And when those demands proved futile, she drew upon and exercised the powers which the Constitution granted her in order to find and secure the property that was rightfully hers. Now, given what many historians have written about white women and their relationships to American slavery, and what we think we know about them and about slavery in America, all of this might strike you as quite remarkable. Many of us might imagine white women's relationships to slavery as it appears in this picture. Her husband is the master. He is the slave owner, and she is merely along for the ride. Enslaved people respect her and supplicate themselves in her presence. Perhaps some of you might even think that white women served as enslaved people's protectors. These imaginings might be true in some cases, but certainly not in all of them. Now, recently, historians have been moving away from this vision, but those who study the lives of white women in the 19th century South continue to diminish the economic significance of slave ownership for these women, and they've provided several theoretical bases for doing so. First, historians have suggested that the colonial era was a golden age for white women throughout the colonies. In this period, white women experienced more autonomy within their respective communities, as well as in their economic and domestic lives. The American Revolution, however, eventuated a gradual diminishing of this autonomy. The Constitution excluded them, and to make matters worse, the decades following the Constitution's ratification were marked by the further development and concretization of highly restrictive laws related to married women's property ownership and women's rights before the law more generally. Second, changes in the market economy altered women's relationships to household and family production, which further undermined their control over their own lives. Women's social networks in the colonial era were conduits of barter and trade, which enabled women to exchange goods produced within their homes for those produced by other women. The introduction of currency, however, displaced these economic networks and pushed women to the margins of the new market economy, thereby enabling men to dominate new economic networks increasingly based on cash. In this rendering, women weren't actively and directly engaged in the new market, although their households' production continued to support white men's labor and market activities. Overall, such a view has made it difficult to imagine women in any market, especially in one where slaves were bought and sold. Third, the post-revolutionary transformations in the political, economic, and social worlds of American men and women led to the conceptual development of separate spheres. Separate spheres ideology suggested that women and men navigated and dominated distinct realms of life. Women's ideal realm was the private and domestic sphere, which was characterized by the home and the family. And men's ideal realm was the public sphere, which was characterized by political, social, and market-oriented dimensions of life. Of course, scholars admit that these spheres tended to overlap, but nonetheless, separate spheres ideology demarcated the home and family as women's ideal domain, and the market, especially one that was filled with slaves, was off limits to them. When discussing white Southern women's commitments to slavery, scholars don't deny that white women were ideologically, socially, and psychologically invested in the institution, nor do they ignore white women's power to brutalize enslaved people, particularly those within the plantation household. However, because many of them seek to understand white women's experiences within plantation households that were dominated by white men, and because they seem more interested in comparing their power to the power that men possessed, their analyses tend to ignore a number of economic dimensions underlying many white women's commitments to slavery. For example, scholars acknowledge that white women owned their own slaves, but few contemplate how personal slave ownership may have shaped white women's understandings of or pecuniary investments in chattel slavery. They also neglect to contemplate how white women's slave ownership could have affected gender relations within plantation households and those existing beyond them. Their tendency to ignore these questions is due in part to the profound impact which the Golden Age theory continues to have. But one idea holds far more sway over all of the others, and that is the assumption that few women could hold property in their own names or control it because of the legal doctrine of coverture. According to the legal doctrine of coverture, when a woman married, she became what was called a femme covert. As a femme covert, a woman's very being and her legal existence were no longer hers. They were immediately subsumed into her husband's, and in the eyes of the law, the wife and the husband became one. William Blackstone, who penned one of the most often cited explications of the legal doctrine of coverture, transfigured this process of subsumption into a form of protection. Blackstone reasoned that the newlywed woman no longer needed an independent identity because, likening the husband to a bird, her groom offered her cover under his wing. From the newly married woman's perspective, however, this wrenching of her rights and the legal denial of her independent existence likely appeared altogether different. Coverture would be particularly perplexing for a slave-owning woman like Mary Martin, because Jack and any other enslaved people she might own, receive, or inherit would become her husband's once she married. The law empowered her husband to sell them, benefit from their labor, collect the revenue they produced, and dispose of them as he deemed fit. Since a femme covert no longer owned or controlled her property, she had no right to sell her slaves either. Coverture forbade her from engaging in commercial endeavors in her own name and without her husband's permission. If someone wronged her, she couldn't sue the person in court unless her husband joined in her petition and put forth the bill of complaint on her behalf. And when an enslaved person decided to run away from the femme covert who technically owned them, her husband would likely pursue the fugitive, not her. Yet in spite of all of this, and whether they were married or not, slave-owning women found a host of ways to own, acquire, and exercise extraordinary control over enslaved people and to circumvent these legal constraints upon their property rights before, during, and after marriage. And I'd be happy to talk about those in the Q&A section. What a narrative filled with doom and gloom, right? But was it true? Well, it is true that the ratified version of the Constitution didn't specifically mention white females. And I emphasize the ratified version because Jan Lewis, who's a historian of the early republic, examined the debates that took place at the Constitutional Convention, and she discovered that at least one delegate, James Wilson from Pennsylvania, proposed women's inclusion in the document. So even though the final version of the document excluded specific mention of women, earlier versions did not. And in spite of their exclusion from the Constitution, slave-owning women like Mary nevertheless benefited economically and legally from two clauses in particular. The clause which abolished the African slave trade to America and gave rise to a domestic one, and the Fugitive Slave Clause, which empowered slave-owning women to go anywhere in the country in order to hunt down and capture the enslaved people they owned. Women like Mary Martin routinely exercised those powers in the years following the Constitution's ratification, and they benefited from the abolition of the African slave trade for the next 57 years. Now, you're probably asking yourself how slave-owning women, a group that was so obviously invested in slavery's perpetuation, could benefit from the abolition of the African slave trade to the United States. Put simply, the clause which paved the way for the abolition of the African slave trade and several other important laws, circumstances, and events actually resulted in the expansion and not the contraction of American slavery. And women routinely seized the opportunities that slavery's expansion afforded to them. In order to see how this could happen, we should take a look at the clause and a few maps that chart its consequences. Article 1, Section 9 of the Constitution states that the migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 for each person. Now, by itself, the clause didn't guarantee the abolition of the African slave trade in 1808. It just forbade Congress from abolishing the trade before 1808. However, three other acts, the 1794 Act to prohibit the carrying on of the slave trade from the United States to any foreign place or country, the 1803 Act to prevent the importation of certain persons into certain states whereby the laws thereof, their admission is prohibited, and the Act to prohibit the importation of slaves into any port or place within the jurisdiction of the United States, which was passed in 1807, gradually but eventually did end it. The Act of 1794 prohibited anyone from engaging in the slave trade from the U.S. to any other place or country. The 1803 Act forbade the importation of non-native enslaved people into any state, which did not permit their admission. And the 1807 Act finally prohibited the importation of enslaved people into the United States. It took effect in 1808. In conjunction with the constitutional clause and these three acts, several other factors facilitated the expansion of slavery and gave rise to a regional slave trade. In the colonial era, high mortality rates in part necessitated the importation of enslaved people to replace those who had passed away. But as the bodies of African captives grew accustomed to new pathogens and their new environment, the enslaved population began to increase naturally. Simultaneously, states that produce crops like tobacco found that doing so depleted the nutrients in the soil, so much so that they were compelled to shift their focus to the production of other crops, which in this case was often wheat. Wheat required far less work and attention than tobacco. So just as some states found themselves with more enslaved laborers, they had less for them to do, but they wouldn't be idle for long. As white settlers moved into the slave states established in the West and the Deep South during the decades following the abolition of the African slave trade, the government passed legislation, the Indian Removal Act of 1830 in particular, which resulted in the forcible movement of indigenous people from their homes in the southeast to lands west of the Mississippi River. You can see that movement here in this map. And without a doubt, Eli Whitney's cotton gin transformed the institution of slavery, the expanding South, and the nation too, because his machine made it possible to cultivate and produce cotton in these new lands more efficiently and quickly than ever imagined. Once in these areas, white settlers quickly realized that they needed far more enslaved people to cultivate their land than they actually had. And their intensified and persistent demands for enslaved labor made men like John Woolfolk, the man who sold Jack to Mary Martin, very, very wealthy. These men made their living buying people in the southeastern states and selling them to settlers in newly established states in the West and Deep South. They also helped to create slave marketplaces throughout the South as well. And this map identifies the most important slave markets in the region. As a result of all of this, at least 1 million enslaved people moved into these new areas, and at least 2 million moved from one owner to another in local contexts. Occasionally, this nefarious business was a family affair. John Woolfolk was a member of a family that built one of the most successful slave trading firms in the 19th century, and he, along with his uncle and 3 brothers, bought and sold slaves in Baltimore, Augusta, New Orleans, Natchez, and places like Charleston too. And just like Mary, women throughout the South had no qualms about seeking these slave traders out and securing their services when they needed them. In other words, the abolition of the African slave trade gave rise to a thriving domestic slave trade and made men like John Woolfolk and his slave trading kin possible. But it also made women like Mary possible. And once it did make women like her, these women could look to and call upon the Constitution's Fugitive Slave Clause to protect their investments in slavery, even in free states like New York. Now let me return to Mary Martin's case. I left you hanging there, so you're probably wondering, did she win? What would you think? In the end, the New York Supreme Court affirmed the trial court's ruling, and Mary did ultimately win her case. But if the Constitution of the United States didn't recognize slavery in national law, as Sean Wilentz recently asserted in a New York Times opinion piece like yesterday, how is it possible for Mary to claim ownership of an enslaved man's body in a northern state that had already abolished slavery? Well, besides Mary's clear tenacity and staunch determination, federal and state governments worked in conjunction to essentially ensure that Mary's property and humans would in fact be protected no matter where she went in the United States. And Mary knew it. When she appeared in court, she argued that she possessed a perfect right to remove Jack from New York according to the Constitution of the United States, the 1793 Act of Congress, and New York state statutes. And Mary was right. In addition to the provisions of the Fugitive Slave Clause and the 1793 Fugitive Slave Act, which granted Mary legal recourse to find and capture Jack and return him to New Orleans without interference, New York law allowed Mary to subject Jack to further servitude within the state, especially if Jack truly was 30 years old at the time of his purchase. In the beginning of the revised 1829 statutes, New York legislators seemed pretty adamant about not permitting slaves to be brought into the state. But they set forth a number of crucial exceptions, which all but guaranteed that Jack would lose this case and that Mary would win, one way or another. In particular, New York not only allowed slave owners to visit the state with their slaves for up to 9 months, the state allowed them to establish permanent residency and keep their slaves with them in a state of bondage, as long as the enslaved people accompanying them were born after July 1st, 1799 and before July 4th, 1827. They could reside in the state with their slaves indefinitely. The only requirement was that the slave owner file a certificate containing the county and state in which they formerly resided, along with their name, age, and sex, and the names, ages, and sex of the enslaved people they brought into the state. This certificate would then be recorded by a clerk and offered as evidence in case the status of these enslaved people was questioned at a later time. New York didn't repeal these exceptions until 1841. So contrary to what Jack claimed in his appeal, he would not automatically become a free man if Mary established her permanent residency in New York, as he argued. And unfortunately for him, New York had revised their statutes the year before he ran away from Mary, and the changes which the legislators made actually worked to strengthen and not weaken Mary's claims to him. Therefore, in this case, the Constitution and New York state law worked together in order to protect Mary Martin's property rights and to keep Jack enslaved. Taken together then, the clause which facilitated the abolition of the African slave trade to the United States helped create a domestic market in which women could buy people. And the Fugitive Slave Clause made it possible for them to capture those folks if they fled, wherever they fled. Take Eleanor Beale's Runaway Advertisement, which appeared in the Washington, D.C. National Intelligencer in late August of 1810. If you look at that red box, what she does there is quite extraordinary. Notice how the amount of the reward increased depending upon the distance an individual might have to travel in order to find and capture her slave, Charles Parker. If they ended up finding him in states like New York, Massachusetts, or Pennsylvania, they'd get the highest amount. This incrementalized reward begins to make sense when we realize that Eleanor clearly understood that her rights to own and possess Charles's body extended beyond the boundaries of Washington, D.C., where she lived, and into the states that we consider to be free ones. As the nation's founders convened in Philadelphia to hammer out the details of a radically new form of government, property-owning women were hopeful that the founders would include them in a more expansive vision of the polity. But they weren't willing to completely cast their lot with these men. Abigail Adams, wife of John Adams, for example, is well known for telling John to remember the ladies as he and the Continental Congress contemplated new laws for the Republic. Yet even as she wrote those words, Abigail was engaging in commercial activities which made sure that she would be economically stable just in case the founders did forget about them. Even before the Constitutional Convention, Abigail actively engaged in financial transactions, such as buying land, speculating in bonds, accumulating her own savings, and get this, even lending her husband John money, all while she was married and under coverture. Although she was still covered by John upon her death, she devised a will anyway, something that married women had no legal right to do at this time. And in that document, she gave all of her property to individuals of her choosing. Want to take one guess? What all those people were? Women. All of her heirs were women. For Abigail, the ability to own and control property offered a crucial kind of freedom, especially for women. In a 1775 letter to her friend Mercy Otis Warren, she proclaimed, "We cannot be happy without being free. We cannot be free without being secure in our property. And we cannot be secure in our property if without our consent others may as by right take it away." And according to Abigail, women shouldn't relinquish this particular kind of freedom without a fight. For Abigail and many other women, property ownership signified happiness and freedom, and these were things to which they considered themselves entitled. While the founders did omit explicit mention of the ladies in the Constitution, they didn't exclude all of them from their particular vision of the new nation because national laws protected slave owners' property rights throughout its borders, and those slave owners included women. The Constitution facilitated the growth of the domestic slave trade and protected slave owners' property rights. And by doing so, the document ensured that a sizable population of women will be able to circumvent the disabilities of their sex and experience an extraordinary kind of freedom. For slave-owning women, the Constitution offered at least two ways of exercising the power and protecting the liberty that came with property ownership. It also made sure that their power would extend into states where slavery didn't even exist. And by doing so, the founders reduced it to a near certainty that such power would only be possible by keeping people like Jack enslaved and protecting the liberties of people like Mary. Thank you.
Thank you very much, Professor. So now the floor is open for question and answers.
Hi, yes. So I'm wondering what your research about women slave owners, what kind of conclusions we can come away from that about mastery and how mastery functioned, because there's now an almost kind of generic historiography about the transition from patriarchal slavery to paternalism and things like that. And so how does that function when a female actor is running the plantation?
That's an excellent question, and it's one that I definitely address in the manuscript that I'm currently revising. So the idea that there are some historians who do examine women's ownership and control of enslaved people, and they argue that these women exercise a form of maternalism rather than paternalism. And for me, what's most important to understanding whether this was accurate or whether this was an ideology is seeing what enslaved people had to say about it. And for both paternalism and maternalism, enslaved people say, great idea, but that's not what I experienced. And so, in fact, what I've found in my research is that women employed the same disciplinary strategies and management techniques as slave-owning men did. They used the spectrum of techniques, whether that went from, as mild and as innocuous as incentives for good behavior and excellent work, to the most brutal, violence and sadism that is possible. Most women, they were kind of operating in the middle. So they used sternness and discipline when necessary, physical discipline when necessary, but generally they employed the same techniques as slave-owning men. And for the same reasons, to preserve and protect the value of their property. Thank you for your question.
I have a very quick question. Hi.
Hi, Diana.
Hi, Professor. So I'm like growing up, like learning about Abigail Adams, and learning about those letters and think of the ladies and stuff like that. Now I'm worried, did she own slaves as well?
She did not own slaves.
Okay, phew.
But, her ideas about property and her ideas about the significance that property held for women is crucial for us to remember because, when you think about that phrase, remember the ladies, it implies that she saw all the power, that she imagined John and the founders possessing all the power. But if we realize that underneath all that, behind the doors and in the parlor, she's exercising extraordinary control of her power when she's not even legally entitled to do so, it suggests that that statement meant something altogether different. It's like, we would like for you to do this, but okay, we're probably going to be disappointed, so we're going to continue to engage in the activities that we engage in to circumvent the constraints that coverture imposes. So I think Abigail is an extraordinary figure because she's saying one thing, but she's doing something very different. And she's taking ownership of her future, her economic stability, and her heirs' economic stability as well.
I was just curious, they had legal recourse if the slaves went to another American territory or state. Was there any recourse if the slave went outside?
That's a great question, Alondra. Thank you. So if an enslaved person went into Spanish territory, it was probably seen as a favorable thing for the Spanish, because the Spanish, particularly when they were having conflicts with the English, were like, come down here, you can be free, we'll give you land. So there were free communities of color in places like Florida, Spanish Florida, because the Spanish were inviting them down in a vengeful way, saying, you don't want to be with the British. If you can make it down here, we'll grant you all of these freedoms. And it was like a dig at the British. So if they moved into those areas, the fugitive slave clause was off, unless off the table, unless an Englishman decided to try to venture into that territory and try to recapture this enslaved person and take them back to American territory.
Hi.
Oh.
Thank you for your talk. So do you know what happened to Jack and Mary after the trial, and were any of your sources personal narratives from either of them or mostly court documents to tell the story?
Unfortunately, I tried to track Mary Martin down, and that is one of the most common names in New York City and New Orleans, because New Orleans is this port where there are an extraordinary number of all different kinds of folks, migrating for work, et cetera. So there are tons of Mary Martins in both New York City and New Orleans, and I could not figure out which of them might be her. So I don't know what happened to her or Jack. I do know that Jack went back, was, reclaimed by Mary and taken wherever she went as her slave. I do know that. But there are no narratives that, kind of elaborate on the outcome of the case. Thank you.
I think it's interesting that you kind of spoke about how white women were the benefactors of the Fugitive Slave Act. And do you see some modern implications of this? Understanding that white women were the first benefactors of something like affirmative action, which is kind of pegged as being something that primarily helps African Americans, and that's negatively connoted to them. So do you kind of, or the development of white feminism in our culture, do you kind of see, do we see roots of this right here in the Fugitive Slave Clause?
That is such a wonderful question. I had not made that connection, and I'm so happy that you did. I think you answered the question, that there are ways, I think there are vestiges, that when we look at this earlier time, it really should cause us to question or at least contemplate the narratives that we have about the present. For example, when you recognize, when you recognize that white women are economically invested in the institution of slavery, and they are a vital part of the project of white supremacy, the actions that they take, for example, in the civil rights movement, where the mothers are, very much in the forefront in the, racial integration, desegregation fight, you really start to reconsider those behaviors, those activities. So I think your connection between this past and this present is absolutely crucial. It's absolutely fantastic, because it is true. If you go back to this time, it really does make you reconsider some of these narratives that we've come to believe as fact, as truth, and not question the motives, the personal motivations that women, and white women in particular, have in engaging in certain kinds of activities. But that's a great, great connection. I'm gonna keep that in mind.
Thank you, Professor Jones-Rogers, for this wonderful talk. As someone in history grad school right now, your model of reshaping the narrative while integrating your own research is something we can all aspire to.
Thank you so much,
so difficult,
Brendan.
and
Thank you so much, Brendan.
You've encapsulated it brilliantly. You mentioned Willen's comment in the New York Times a couple days ago, which in itself was a response to, I believe, what Bernie Sanders said at Liberty University. Sanders says, racism is ingrained at the founding of the Republic, and Willen says that's an incorrect reading of the Constitution, if I'm understanding correctly. If Willen was here, what would you have to say on a discussion about Constitution Day?
Well, what I would say, thank you, Brendan, for putting me on the spot and also asking me that question. So if you look at what Bernie Sanders actually says, he doesn't mention the Constitution. And if we think about the founding as happening before the Constitution, removing or uncoupling the founding from the Constitution, and think about the founding as the establishment of a colony in which we are settling, Europeans are settling, Bernie Sanders was actually, he was correct. Because in the 1660s, you can begin to see this dual system of justice emerge, one in which white servants, for example, are protected. There are certain concessions granted to poor whites or landless whites. At the same time, you see certain rights being stripped away from people of African descent. You see a system of racial slavery being legislated. Certain activities, for example, interracial intimacies being criminalized. So you see a system developing in the law as early as the 1660s that really does, I think, substantiate what Bernie Sanders is saying about the importance of race in the construction of our nation. Because if we begin there, then we can see how Bernie Sanders is correct. And as I showed here, when you look at how the Constitution is operating on the ground versus how it's written, then you realize that, in fact, race was very important, but slavery was absolutely crucial to the nation's, the unfolding nation, the development of the nation. So when you look at how it's working on the ground, when you look at what Mary Martin is doing, slave-owning people like Mary Martin are doing with those clauses, you realize that they very much see slavery as instrumental and absolutely vital to the Constitution. So I think looking at what's happening on the ground and also beginning or reconceptualizing the founding as something that happens well before the Constitution and the ratification of that document, Bernie Sanders is right and Sean is on shaky ground.
Hi, Professor. Hi. This is my first time to hear the slavery history of American history.
Oh.
Yeah, I just learned the history in my history textbook in China.
Mm-hmm.
So I'm wondering what happened to the slaves in the mid 18th century. Are the slaves get free after the Civil War? And what are consequences of the slavery at the end?
Okay, so just let me reframe your question. So you're asking what happened to the slaves after slavery? How did they become free? How were they emancipated? Yeah. And then what happened to them after emancipation? Yes. Okay, so some people, depending on the historians that you talk to, some focus or emphasize the acts of our government. You know, what our government did to kind of eventually end slavery. However, historians of the African American experience also examine what African Americans themselves were doing, how they pushed the government to do certain things. For example, African Americans were actually locating, pinpointing, identifying where federal troops were encamped, and they would flee to federal encampments, federal troop encampments. So in response to that, there were so many coming that generals, military officers were like, what are we supposed to do with all these enslaved people? They don't want to go back home. What are we supposed to do with them? Their actions actually called for a series of questions to be posed by people in power, which eventually did lead to legislation that protected them in a category called contraband. So they were considered property, but they were considered to be property that could be legally confiscated because it was being used, it was owned and being used by rebels against the state. So the actions of African Americans pushed the government to act in certain ways, those ways eventually leading to emancipation. Now, that happened routinely. There were also individuals who challenged and resisted slavery as it was on the ground within, plantation households, but also in the plantation landscapes. And those actions, although they seem minor in comparison to people fleeing or, for example, enslaved men enlisting in the Union Army, they nonetheless destabilized slavery where it existed. So all of those actions in relationship to each other chipped away at the kind of stability of slavery while the battles were going on the fields. Now, we know that in 1865, enslaved people were freed by government, by the federal law. What happens after that? We tend to think that was it. Enslaved people were free. It was great. They're where they are now, that they've become free and that's it. But what ends up happening is the Southerners, particularly, are not particularly pleased with the fact that they just lost this property. These are individuals who are valuable, extremely valuable. So now that value is zero overnight in some occasions. Can you imagine if you own a home in the Berkeley Hills and it's millions of dollars and then the next day it's worth nothing? Psychologically, that would be absolutely traumatizing. So many Southerners actually impose restrictive laws to try to create a system of pseudo-slavery. So enslaved people, newly freed, actually found themselves in circumstances that it smacked of slavery. And it took them a very long time to remove themselves from that situation. So Southerners essentially implemented laws that really recreated a system of servitude that looked very much like slavery. And so it took free people, a long time to really kind of unravel that. And I think we saw the kind of eventuation of those efforts in the civil rights movement. And, it's been a gradual process. It's not over, but it's been a gradual process.
Hello, Professor. I just have a quick question from stemming off the question before this previous one. So, when you said that the 1808 constitutional, waiting to ban the slave trade until that time, you said that it expanded the slave trade domestically. Would you say that the motivations of that clause were to expand slavery?
No, I think it was an unintended consequence. Because I really think from what I've read, because I'm not a constitutional scholar, but what I've read, suggests that the founders weren't quite ready to assume the responsibility of abolishing the slave trade. They wanted, to leave that for subsequent generations. But I think that the expansion was an unintended consequence, because what happens with the abolition of the African slave trade is that instead of looking outward, looking elsewhere, looking beyond the borders of the United States for enslaved people, they had to look inward. They had to find another source of enslaved labor. And so they turned inward and they looked within their borders and realized that with this natural increase of the population and in states that didn't need them, they had a ready source of enslaved laborers that could then be moved into the West and could cultivate those lands. So I think it was an unintended consequence. And those other factors, I think, really created circumstances that allowed for the expansion and development of the domestic slave trade to really take shape and take hold.
Hi, Professor.
Hi, Vita.
You mentioned, or it became clear after this discussion, that the separate spheres ideology presents an idealized rather than realistic image of gender roles in early America. And so I was wondering, what alternative frameworks are there to approaching early American and gender history, and who does this ideology benefit? Why has it remained the prevailing mode of thinking? It fails to account for enslaved women, enslaved men, and so how do we study early American history in a way that's inclusive of peoples in bondage, and in a way that recognizes the agency women had in in America as slave owners or as property holders?
Okay, so I'm going to tackle the separate spheres question first. What I like to do is I like to think about any kind of ideologies or laws in reverse. I think I mentioned this in class last week. So when you see a law and it's prohibiting something, you should think about the fact that people are doing it, right? So if they say don't do this, that means people are doing it. That's how I like to think about laws that prohibit things. And so in this particular case, with the separate spheres ideology, you really see this ideology being promoted in advice literature. So for example, we have Cosmo Now. They had all these, kind of periodicals that gave them all kinds of advice about life. And so essentially what you're seeing is these typically male authors encouraging women to embrace this domestic sphere ideology, the separate sphere ideology. So if we think about it in the same way that I like to think about the law, what they're doing is they're trying to impose a vision of how they imagine things should be, how they want things to be. And what that suggests is that women are doing something else. So these women are really moving around, they're everywhere, including in slave marketplaces, which my scholarship examines and establishes. And they're doing the exact opposite of what the ideology suggests. Now, this is not all women, but there are many women who cannot afford to adhere to these ideologies. Their lives just can't. They just can't. So in that sense, I like to think about it in the opposite. The ideology suggests what they hope for, but what women are doing is far different than what the ideology suggests. And in terms of what my work does, I'm going to put this over here. What my work does is exactly what you're asking in relationship to enslaved people, and you incorporating them more fully into the narratives of American history. So while I focus on white slave owning women, the story that I tell about white slave owning women is the story that the enslaved people that were owned by these women told. So in the 1930s, I don't know if many of you are familiar with this, but the Works Progress Administration actually went throughout the South and located as many formerly enslaved people as they possibly could in the 1930s, and they interviewed all of these individuals. And those interviews were collected. There are about 2,000, and they estimate that that's only a small percentage, a single-digit percentage of the enslaved people that are actually alive in that time. And so you can read these on the Library of Congress's website, and enslaved people tell stories about their mistresses, their female slave owners. So one of the ways that we can incorporate these enslaved people more fully into American history is to see what they have to say about American history, not just about enslavement, not just about being Black, but what do they have to say about America, about being American, about other Americans? See what they have to say. They were experts on some of this stuff. So what I do is I actually take what they have to say seriously, and I construct a narrative about other Americans from those words. Of course, I legitimate and substantiate those words with other documents. For example, in the case of slave ownership, I look at legal documents and financial documents. I've even looked at military correspondence. And all these different voices actually legitimate what enslaved people are saying. So starting with the enslaved people to see what they have to say about American history, about certain dimensions of American life, I think is a way that we can more fully incorporate them into our conceptualization of American history more broadly.
I just want to thank. Oh, that's loud.
It's okay.
I just want to thank you for this. This was really insightful.
Thank you.
So I guess based on your research, how would you suggest people of African descent and women sort of in the modern day relate to the Constitution and view the Constitution, knowing that it played such an integral role in keeping their ancestors oppressed and marginalized? How should us, Berkeley students, perceive that one of the guiding and founding documents of the nation many of us call home?
Wow. I don't think as an African-American woman, I'm not quite sure if I've worked that out myself. I mean, I'm learning more and more about, the laws that really are at the foundation, at the kind of the gut of our nation, and how it really constructed the bifurcated system, this kind of dual system of justice that you hear a lot of the kind of, Black Lives Matter movement activists talk about. When I see that happening in 1660, it makes me less optimistic about how much change can actually happen. So I'm probably not the best person to give you hope. But I think, we have to understand that as our foundation before we can really understand the magnitude of the changes that are required to make this a place where we can fully integrate people of color, particularly African Americans, particularly descendants of slaves, into the polity. We have to understand that in order to understand what kind of change is required in order to make that kind of life for African Americans possible. And I don't think we've gotten there yet. I think we look through, little windows and we see little segments or portions of our history, and we think that that's all we need to kind of contend with. But I think it's really from the ground up, because the democracy in and of itself was in fact constructed. I'm not the first one to say this. Edmund Morgan is probably one of the first to say this, but the concept, the principle of American freedom was contingent upon American slavery. And so how do you uncouple those things? I think we have yet to uncouple those things. So we've got a lot of work to do, but I think we need to begin in that era, the 1660s, and understand how that happened, how it unfolded over so many generations, and what it's going to take to, bring the ideal of the founders alive for all of us.
One more question.
Well, I, for one, would like to thank you.
Thank you.
This was very stimulating.
Thank you.
You are teaching a large enrollment class, I'm sure.
I am.
How many are in there?
134.
Okay, so I would say Wheeler Auditorium would be your next venue, as far as I can see, judging from the students you have here tonight. But seriously, that was a wonderful way to present Constitution Day. I thank you all for being here, for your wonderful questions. We do this every now and then, but we organize these things based on often student groups that make suggestions for programs. This was one we were doing here. But if you're a member of a student group, there's a nice little poster around the corner here on the wall. We give stipends to the student group, and we also encourage you to put a program together that we have some budget to do. So if you're a member of a student group on campus, think about this. Otherwise, we are organizing a program with veterans that's coming just before Veterans Day in November, and I encourage you to come back once we get that together and invite you to come in. And again, Professor Jones-Rogers, thank you. And
thank you, David.
Good luck on the rest of this semester.
Thank you.